The starting bell here, so it's time to begin. My name is Larry Dessam, and I'm the Dean here at the University of Missouri Law School, and it's my great pleasure this morning to welcome you to Broke and Broken, Can We Fix Our State Indigent Defense System? The 2010 symposium sponsored by the School of Law and the Missouri Law Review. It promises to be a very thoughtful and interesting day. In his argument in the United States Supreme Court in Gideon versus Wainwright, A. Fortas told the justices that our adversary system means the counsel for the state will do his best to present the case for the state, and counsel for the defense will do his best, similarly, to present the best case for the defendant. And from that clash, there will emerge the truth. This, however, assumes that both the prosecution and the defense have the resources to adequately and zealously represent their respective clients. And unfortunately, on a day-to-day basis in courtrooms across the state and across the country, that is not necessarily the case. It is simply not an overstatement to talk about the crisis in criminal indigent defense. Today's symposium brings a stellar cast of legal scholars, attorneys from all across the country to address these issues that are so crucial to us all. As a portion of the symposium, we will have the Earl F. Nelson lecture immediately after our first lecture, and we are thrilled to have Stephen Bright with us to present that lecture here today. This symposium is the work product, the result of many individuals, and we need to thank a group of individuals for making this possible. First of all, I'd like to thank all of you who are with us here today. I'd also like to thank and recognize our public defenders. I know we have, I wonder if the public defenders are with us, if you might stand so we can recognize and thank you at this time. It doesn't look like there's much criminal work being done in Missouri today, and we're pleased that you're here with us today. If we have any prosecutors or judges? All right. We thank all of you.
Just as well.
We thank you all for making equal justice under a law a reality for all of us in the courtrooms here across the state. We also need to thank particularly our Missouri Law Review and the students who make that law review work so wonderfully for us. They are here with us in the courtroom. They are throughout the building. They have worked literally for months on this. I wonder if you remember the Missouri Law Review, if you would stand so that we can thank you. And we thank you for the work to date, which has been significant, as well as the work that you will do in the months to come in bringing this symposium to a written issue that will be relied upon by scholars, policymakers, legislators all across the nation and around the world. And I particularly want to recognize Adam Hanna. Hanna, can you wave your hand? Adam's worked on this for about a year. So. There are several law review staff. I see Robin Nichols back there. Robin, give us a wave. Robin also has worked many long hours on this. All of you presenters have talked with Robin, have corresponded with her, so we want to thank Robin for her good work on this as well. And also want to note, although they're not in the room, I don't think, Casey Baker, Cindy Shearer, and Risa Kearns, because they too have made this possible. The symposium, though, has been the dream of Professor Rod Uphoff since last year at about this time. Today we're all the beneficiaries of his wisdom and of his hard and creative work. Rod became the inaugural L. Thomas Missouri Endowed Professor of Law here at the University of Missouri in 2001. After obtaining his J.D. from the University of Wisconsin, he was engaged in private practice and then worked as a public defender, ultimately serving as chief staff attorney of the Milwaukee office of the Wisconsin State Defender. From 1984 to 88, he served in the law school at the University of Wisconsin. He then served as a professor of law and director of clinical legal education at the University of Oklahoma for 10 years. While at the University of Oklahoma, Professor Uphoff was appointed by Governor Frank Keating to the Oklahoma Indigent System Board. He also was appointed to represent Terry Nichols in the Oklahoma City bombing case, serving on the defense team with Professor Barb Berkman, who is one of our other presenters here today. Professor Uphoff has written widely in the area of the criminal justice system and indigent defense systems, and has edited the book for the American Bar Association, Ethical Problems Facing the Criminal Defense Lawyer. We're proud and pleased to have Rod as one of our faculty here at the University of Missouri, and I'd like you to join me in welcoming and thanking Rod for his hard work to make today.
Thanks, Larry. My friends and students know that this is going to be an extremely difficult challenge for me because I've been told to keep my remarks very short. And those of you who know me know that that is not one of my strengths. So I will try to be very short. As Larry said, we have an excellent group of presenters here today. I think we have much to discuss and much to talk about. Let me give you a quick overview as to how this day is going to proceed. Our first panel I will introduce shortly. Will focus on really the crisis here in Missouri and across the country in the delivery of indigent defense services. After the three presenters each talk for 20 minutes, Norm Lefstein will commentate and give us his insight on their and react to their presentations. At 10:15 today, Steve Bright will give the Earl F. Nelson lecture. And as Larry said, you're in for a real treat because Steve is a very powerful and compelling speaker, and he will talk to you about his many years in working in indigent defense and dealing with the problems in our criminal justice system. This afternoon, and I hope that many of you will stick around this afternoon because we have two other panels, one starting at 1 o'clock and then third panel at 3:15, and we've got excellent presenters and commentators speaking this afternoon as well. And the idea is that we will use this first panel to kind of provide us an overview of the issues that individual lawyers, their clients, and those administrating public defender systems and other systems for delivering services to poor people accused of crimes. We're going to look at the problems, both ethical and practical problems, that those clients, lawyers, and administrators face. And then in the second and third panels, we're going to focus more on the impact of those problems in the delivery of indigent defense services on other actors in the system and the extent to which administrators and judges who are grappling with the problem of too high caseloads, too little resources, how we might begin to more efficiently, if that's possible, use our resources. And then in the last panel, the focus of the last panel will be the extent to which, if we can't shake adequate resources out of legislators, what kind of measures can and should be taken to try to find ways to ensure that there are adequate resources. Is litigation the answer? And if so, or if it is, do judges really have the power to order state legislators to provide adequate resources? Or are we going to continue to limp along the way we have for the last 50 years in trying to provide real promise or real meaning to the promise of Gideon? So I obviously could drone on for a long period of time, but I want to get to the first panel because we have three people who have all spent time in their careers dealing with the issues of delivery of indigent defense services. And in all of your materials, you have a longer bios for each of these speakers. I'm just going to very briefly introduce Phyllis, Peter, and Adele, and then Norm Lefstein. Phyllis Mann will speak first. She's the training director, really, for the National Legal Aid and Defender Association. That's an organization of lawyers and organizations who provide both civil and criminal representation to poor people across this country. As her bio indicates, she's a very experienced lawyer who's done public defender work both at the trial and appellate level. in Louisiana in state and federal court, so she has labored long in the trenches and has much to offer. Peter Joy is the Vice Dean at Washington University. Peter runs a criminal defense clinic at Washington University, ran a criminal defense clinic at Case Western, is one of the country's leading experts in criminal defense ethics and in ethical issues, and that will be the major focus of Peter's presentation. Our last presenter, Adele Bernstein, is a professor at Pace University, where she also runs criminal justice clinics. Adele was a public defender in New York City, and has been very involved in both the evaluation and monitoring of criminal defense performance in New York City, and also has much to offer in terms of her views of the way we ought to structure public defender programs and how we ought to evaluate those programs. And our final commentator for our first panel is Norm Lefstein, the former dean of the University of Indiana at Indianapolis. Norm has more experience. We have a group of very experienced commentators, but Norm is really the dean of all of us. When I graduated in the law school of 1976, oh so many years ago, I was already reading things that Norm had written. So he has been looking at, studying on behalf of the ABA, on behalf of the NLADA, on behalf of every national group, the problem with public defenders and the delivery of indigent defense services for over 40 years. So his insights will be valuable not only to all of us in the room, but he has been writing and studying the delivery of indigent defense services for many years. So we are very pleased that he's able here to share his insights with us as well. So without anything more, I'll turn the podium over to Phyllis.
Wait a minute, see if I can actually operate the technology. To get started. Thank you for having me, but most importantly, thank you for addressing this topic, because there's probably not a larger topic in criminal law in America that has a greater effect than indigent defense services. So before we can really begin discussing concretely the ethical obligations of lawyers in indigent defense, I think we have to first know exactly what we mean when we say indigent defense and indigent defense systems. A lot of times we come to these meetings and we all say those words, and we all have our own personal definition. We think everyone else shares our definition. We think we're all talking about the same thing, and we're not. So I want to begin my remarks today by outlining what I mean when I'm talking about indigent defense and indigent defense systems today, and a little bit about what we do know and what we don't know about that in America. First thing is that today we're going to talk only about state indigent defense systems and not the federal public defender and CJA system. There's a whole separate system out there in the world that operates in the federal courts. They are perhaps more of a system than anything we have in the states, but it's different, and we are sort of excluding that today. I do want to let you know that that doesn't mean the federal government is wholly uninvolved in the provision of indigent defense in the state courts. Last week, the Department of Justice held the first in a decade symposium on indigent defense in Washington, D.C., paid for an awful lot of people to come there, and that's nice of them. It's our dollars, of course, but they did do that. Brought in a lot of people from all over the country to meet about indigent defense, and it's a focus of this administration. This morning, if you got to hear NPR this morning, the Department of Justice has announced its Access to Justice Initiative, which is going to be a department within the Department of Justice, headed by Harvard Law professor Larry Tribe, and I think that bodes really well for all of us. So, we're not talking about the feds, but we certainly welcome their involvement in our state systems. The second thing is that the way our systems get administered, is that going to work? Where do I point? That's not going to fit. Let's try this. Columbia. I don't know if the colors show it very well. I apologize for that. Some of those systems are run by statewide commissions. Some of those commissions have complete authority. Some of them have virtually no authority and can just sort of advise as to what people should do. So that's the ones that are green, if you can distinguish. Some of them are partial commissions in that there is a commission that administers some part, but not all of what occurs within indigent defense in their state. Some states have a statewide public defender, but no commission, and normally that means that their direct gubernatorial appointee serves at the whim of the governor, and if the governor doesn't like what they're doing, they can fire them. And then many states have no statewide commission at all. But even this doesn't tell you much about what's going on in terms of how lawyers actually get appointed. Because within all of these states, even if they have a state commission, they may still operate their public defense systems on a county-by-county basis. So we've got 50 states plus the District of Columbia, but we've got 3,100 and some odd counties in the country. And in many places, our public defense systems, indigent defense systems, are being administered at the county level. And I'll tell you that even within those counties, many times there are multiple layers of indigent defense system within a given county. If you're in a county with a large metropolitan area in it, you may have 27 small cities, and they may all be administering their own little mini indigent defense system. So this just gives you an idea of how little system we actually have. And then in terms of funding, the maps don't match up. I'll let you know that what you just saw in terms of who administers doesn't have a lot to do with who funds. And again, I apologize for the colors. But we have some places where 100% of the funding for indigent defense comes from the state, which is pretty much what we have here in Missouri, right? Also the case in Alabama. Those two systems don't look anything alike. We have some places where most of the funding comes from the state, but that could be 51, 49%, comes from any other number of systems, from counties, from cities, from ticket collection, from whatever people want to make up about ways they want to fund indigent defense. And then some are fully county funded, and some are primarily county funded. And I just want to tell you, for example, Arizona and Michigan, less than 1% of the money for indigent defense in those two states comes from state government. The rest of it is gathered together by hook or by crook by people in counties. So there's no consistency at all to how we fund or how we administer. Then we have, once all these administering systems are deciding how they're going to provide indigent defense, they do that in a whole lot of ways. Sometimes they do it through full-time public defender offices. When I say today public defender office, what I mean by that is a governmental agency with full-time employees who are paid by the government, and they don't do other things. They don't take private cases. They don't operate an office down the street where they do bankruptcy or divorce. That's what I mean when I say a public defender office. But I want to let you know that a very small percentage of indigent defense representation in America occurs in a public defender office. Most of the representation is provided by private attorneys who do not work in a public defender office. In the state of Alabama, all indigent defense services is provided by public lawyers who have an office of their own. They can practice anything they want in that office, and they get appointed by a judge when a judge needs a lawyer to take a case. And the judge determines who they choose. And there aren't a lot of rules about that. That's the way it works in most of the counties in Texas. We've got 254 counties in Texas, and we have 15 public defender offices in some form or another, and most of those are not full-service offices. So, and as you can imagine, in addition to just when we decide that we want to do provisions of indigent defense by contract or by appointment rather than by public defender office, we also have all those instances where we've got multi-defendant cases. Drug cases, it's not uncommon to have, several defendants. And even if you have a public defender office, the first one will be represented by the public defender office, or the most serious case, perhaps, but all the rest of those defendants are going to have to be conflicted out and go to private counsel. So as a result of that, we don't have a system of indigent defense here in America. We just have a lot of ways of doing it. And we try to sort of create these little umbrella vocabulary words just so we have a way to talk among ourselves. The other thing I want to tell you is that a lot of people call themselves a public defender who don't meet that definition I just told you. So you may hear people say, oh, he's the public defender in our county. But in fact, he's a part-time administrative law judge in the county next door, and he's got a private office where he mostly does personal injury law, and he doesn't look like a public defender. So I'd like you to be wary. Saying someone is a public defender does not make it so, okay? And no one knows the identity of all of the indigent defense service providers in our country. No one does. The Bureau of Justice Statistics conducted a census over the past several years. It was one of the most successful censuses of indigent defense ever done, and it told us very, very little. What they learned in the course of conducting this census is that they don't know who provides indigent defense in America. They were able to, we have a lot of information from it, and I don't want to belittle its value because it's so much more than what we've had before. But they really were forced to focus on just those full-time offices that are governmentally funded, that meet my very narrow definition. And they agreed that that doesn't come close to telling us who everybody is. So that's what we know and don't know about that. The next thing is who is being represented? Who are the clients in these systems? And nobody knows, right, the actual number of cases or clients who receive public representation each year. Anecdotally, we suspect, and you're going to hear all of us sort of, use some numbers, we usually talk about something in the neighborhood of 80 to 90% of every criminal defendant in every criminal courtroom, from the lowliest traffic violation all the way up to federal capital murder. 80 to 90% of those people are either represented by public defenders or eligible to have been had they not waived counsel. So we do know who is supposed to be represented because we've got all this great case law from Gideon coming forward, right, that tells us if you're facing loss of liberty, and then, over time people started to talk about that in felonies, misdemeanors, even if it's a suspended or probated sentence and you're not going directly to jail, juveniles and juvenile delinquency cases, direct appeals following a guilty plea, some parole revocation, and probation revocation. But I want to let you know that there are big gaps that we're not quite sure about, including things like whether or not somebody gets a lawyer in a treatment court. And treatment courts are proliferating all over the country, and people are being sent to jail as a result of things that occur in those treatment courts, but they're not always getting lawyers. Post-conviction and habeas proceedings, especially in death penalty cases. What about parents who are losing custody of their children? The Supreme Court spoke on that in 1981, but a lot of people think they may revisit it someday. What about children who may be taken from their homes as a result of CHINs or FINs or whatever they're called in your jurisdiction, child in need of care, SINC proceedings, and whether or not they're entitled to counsel. So we've got big gaps that remain that the law hasn't answered yet. And we know that huge numbers of people, even the ones that we're sure are entitled to counsel, are waiving that right. Now, there's a question, again, as to whether these are informed and voluntary waivers or whether they're coerced. I would think it's safe to say that most of us who work in the field think that they are largely not voluntary. And to the extent that this is true in the adult courts in America, it is likely even more true in juvenile courts. Juveniles are likely, in greater numbers, waiving their right to counsel than adults are, and it is far less likely, at least in my humble opinion, to be not voluntary on the part of juveniles than on adults. There are no national standards for deciding who is indigent. Okay? So even though We know in all these categories of cases, if you are indigent, you are entitled to counsel. There's no rules about how we decide who is indigent. Some jurisdictions decide that they're not going to make any determination, do any thinking about this at all. And if somebody walks in and says, I need a lawyer, they give them one, right? Some places, they say, well, if you say that you need a lawyer, then we're going to make you give us some amount of financial information, but we're going to believe whatever you tell us, right? And then we'll decide whether or not you're eligible based on the numbers you told us. Some places spend a lot of time and money doing a lot of verification of defendants' financial information, which, you know, can start to get a little amusing if a person is homeless, but yet we have to verify all of that before we can provide them with counsel. But, you know, if we're providing counsel at taxpayer expense to people who could afford their own counsel, then someone's not getting a lawyer who needs one, right? So there's a balance here, but there are no national standards. There are no national rules. So this means that I might be entitled to appointed counsel in County A, but if I step my toe over into County B, they've got different rules, and I'm out on my own over there. No consistency, no national rules. So again, we know, we know when, is that right? Yes. We know when people are supposed to be represented in our system in terms of their cases, right? So in addition to from institution of prosecution to conclusion of a proceeding and all of those types of cases we looked at, we know that there are other times when clients are also entitled to be represented by public counsel if they can't hire their own, right? But we know, see this Rothbury case, 2008, right out of Texas, right? Initiation of adversarial process without regard to involvement of the prosecutor. We know that at least in Texas, Mr. Rothbury wasn't getting represented when he was supposed to, and that's happening all over the country. We just don't know how much. So, to whatever extent that we say there is a process, and we know there are enormous problems, we also know that the problems are even larger than we can quantify or demonstrate. Okay, so now I want to go from the global down to the concrete individual lawyer, because the short answer is that all this representation is being provided case by case, client by client, by individual attorneys who get their bar cards jurisdiction by jurisdiction. And in the return for the privilege of being a lawyer, each one of us have professional and ethical obligations that we're required to live up to at all times in every case. And these obligations don't change whether we're hired and paid a lot of money to represent Microsoft or the President of the United States, or whether we agree to represent a person who's facing loss of liberty and can't afford to hire their own lawyer. So I'm going to talk about these rules for a second. I'm going to use today the American Bar Association Model Rules of Professional Conduct. Most of us got to study those in law school. When I was in law school, we called them the law of nowhere, right? Because they're not really the law anywhere, but 49 states and the District of Columbia have professional conduct rules that follow the format of the ABA model rules. And for purposes of our discussion today, the variations among the state rules of professional conduct don't have a whole lot of impact. So I want to look first at what is it that the rules of professional conduct tell us that a lawyer is supposed to do when representing a client. I'm not going to go through all the rules. I just want to hit some highlights because this is really easy. What are you supposed to do? What are you supposed to do? A lawyer shall provide competent representation that requires legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. And reasonably means the conduct of a reasonably prudent and competent lawyer, right? Seems pretty simple. So, a criminal defense lawyer who's representing a client, even if they've been appointed, has to provide the legal knowledge, skill, thoroughness, and preparation that a prudent and competent lawyer would think was necessary for that representation. When is the lawyer supposed to do this? A lawyer shall act with reasonable diligence and promptness. And I'll tell you, I've truncated these to make them fit on the screen. There's a lot more words around here, but this is what they say. A lawyer shall act with reasonable diligence and promptness in representing a client. Make reasonable efforts to expedite the litigation. That means that clients should not be sitting in jail for 2 years, 4 years, 6 years, A, without counsel, B, without their counsel showing up to talk to them or doing anything in their case, right? Okay. And how? How do we provide this confident representation? Again, there's a lot of stuff we're going to talk about, but some real simple ones. Right? First one is we have to talk to our clients. We have to abide by their decisions and consult with them as to the means by which the objectives of representation are going to be pursued. We can't do that if we don't go talk to them, right? We have to promptly inform the client of decisions as to which they have to exercise consent. Reasonably consult with them about the means that we're going to accomplish their objectives. Keep them reasonably informed about the status of their case. Promptly comply with their reasonable requests for information and consult with them about any relevant limitations on our ability to represent them. But a lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions. We can't explain to our clients if we don't know. Okay, so if we don't know what's going on in a client's case, we cannot explain it to our clients so that they can decide about the objectives of representation. Okay. In addition to talking to our client, we should exercise independent professional judgment, right? Always. A lawyer shall exercise independent professional judgment and render candid advice. We're allowed to refer to things not just the law, but economic, social, political, moral factors that might be relevant. Again, if we don't know enough about our client in our cases, we can't begin to refer to those things, even though they might be relevant to the client's decision making. So we need to know about them. We shall not permit a person who pays us to direct or regulate our professional judgment. Just like if a pimp comes in and hires me to represent a hooker, I can't let the fact that the pimp paid me determine how I represent the hooker, right? If a judge pays me to represent a poor client, that judge ought not be directing the way in which I represent my client. In addition, I have to know the law and prepare the case, because this just takes us right back where we started. Competent representation requires legal knowledge, skill, thoroughness, and the preparation reasonably necessary. How am I doing on time? Okay, all right. Okay, very good. All right, so let me just tell you that the rules are really plain. If you can't do these things, you must decline appointment. And if you're already in the case, you must withdraw. There's a whole lot of standards that tell you how to do all this and exactly what you're supposed to do. A lot of people are going to talk throughout the day about those detailed standards, and I'll give it up.
Thank you, Chris.
I'll let you take this from me. Okay. Nice overview. Nice. Nice seconds.
All right, and before I start, I'm going to take this whole well, this might not. There you go. There. Now I see how it works. Thank you very much, especially to the Missouri Law Review and Rod Uphoff. And I'm here to talk about revolution today.
Good.
And it hit me a little bit into my preparation for this, why this is revolutionary. And it's revolutionary for a few reasons, but the beginning reason is the Sixth Amendment was a revolutionary concept. The right to counsel didn't exist in Great Britain, and that was one of the things that our country was founded on. And so having a right to counsel and having that in the Bill of Rights was a revolutionary ideal that this country was founded upon. I think in the criminal justice system, it's the most important of all the rights. The Fourth Amendment is an important right. The Fifth Amendment is an important right. But if those rights get denied to you, if you don't have a lawyer, there isn't a judge in the country that's going to investigate or listen or think about those rights. So the Sixth Amendment is a revolutionary concept. The second revolution was Gideon. When the court decided Gideon, the court changed what had existed up to that point in our jurisprudence. At the state level, eventually it was recognized that if a person faced a capital case, the death penalty, they could have a lawyer represent them at the expense of the state. But when Gideon was decided, Gideon initially established that any person facing any felony had the right to an appointed lawyer. So that was a revolutionary concept. The third part of the revolution, and this is, I don't know if the Missouri Law Review realizes that they're part of a vanguard of a revolution here, but the third revolution is something that came out as I was starting to prepare for this. And, you know, I was doing some research, and the first thing that one discovers is there's been very little treatment by legal scholars, principally law professors, you know, kinds of people with beards, and you'll see a few of them today, writing in this area, because there just really aren't a lot of law review articles out there. So I did what my students typically do, and I Googled to see if I might pick up anything. And, you know, I was familiar with a lot of reports. One of the best reports, and we're fortunate to have Norm Lefstein here with us, because he was the primary author, if not the author, of Justice Denied, a report that was done by the Constitution Project. Yeah, that really goes into detail, and there are a lot of ABA reports. Sorry. Okay, there we go. And it's available for a small price out there. And it's very thorough, and there are a lot of other ABA reports, but there has been very little by law professors. But there's starting to be something out on the internet, and I discovered there is a website called Public Defender Revolution. And if you take a look, if you could read the quote there, it basically says, you can't give me too many cases, you can't give me too many prosecutors, you can't tell, you know, essentially have me appear before judges who don't understand what my role is in the system, and then expect me to play along and not provide competent counsel to the clients that I have. And so I think that not only will the Missouri Law Review contribute to the revolution by getting some good scholarship, hopefully good scholarship, out into the stream there, but it's supporting the revolution that all of us here in this room, I think, are participants in, which is a revolution saying that when the Constitution promises something to every person in this country who's poor, that they have a right to appear before judges on an equal footing with somebody who's rich, that it has to mean something. Or we might as well tear up the Constitution and say that it's been a lie all along. So we are in crisis, and it's this disconnect between the promises, not only the promises in the federal Constitution, but in state constitutions, sometimes state laws, and the reality. We know, and people, other commentators will talk about some of the other issues that are present here, but when one examines the problem, the crisis in indigent defense services, excessive caseloads really is the most pernicious, but there's also a problem about lack of funding for expert witnesses and investigators, and the low pay rates, not just for public defenders, but for all the other various people that Phyllis referred to who are out there, whether they're court-appointed or contract defense lawyers. So the topic, Broke and Broken, is really a topic that I think captures the situation that we're in. And there'll be a number of potential reforms that other speakers will talk about. But what I'm going to do is focus a little bit more right where Phyllis left off on some of the ethical dimensions of the crisis. And everything that Phyllis says, I'm in total agreement with. It lays the foundation for it, so I'm not going to report or spend time going over some of the same ground. But when I did take a look at Public Defender Revolution, I noticed in the Public Defender Bill of Rights, there were 3 rights among them that really are the ones that make real the Sixth Amendment. And the first is a right to a meaningful weighted caseload standard. Okay? Something that really will regulate the amount of work. The next are judges who understand the public defender's role in the justice system. Many judges do, but there are a lot of judges that don't. And in a few minutes, I'll refer to a recent case in Missouri that involved at least one judge who didn't quite understand the role of public defenders. And then the third piece, the right to a boss that will back me up. Those are the supervising attorneys and managers that I want to talk about. Essentially, and if you go into any public defender office, you'll hear the line public defender, the person on front line day in and day out, referring to the supervising attorneys and the managerial folks as their bosses. And that's because they are. And I want to conclude, after talking about the ethical implications, with a discussion of some strategies. So Phyllis already talked about how Gideon was developed through subsequent court cases to expand beyond the concept of a right to counsel in felony matters to a right to counsel in a whole variety of other cases. Each one of those decisions, I submit, was the right decision, because when a person faces incarceration, they need to have somebody standing by them, because it's more than a property right. A fine, affects your property, but going to jail not only affects your freedom to move about, but it can lead to you losing whatever property you have left, losing your connection to your family, and essentially losing your life during the time that you're taken out of society. And so each one of these cases, if one wants to think about kind of a faucet, was sort of turning open the faucet a little bit more, and what's raining out of that faucet are the number of cases that are going on to public defender systems. And each time there was a Supreme Court case that increased the number of cases, how many people think the state legislators went ahead and increased the funding for indigent defense services, right? Not a single one. So each time that faucet opened, it meant more and more strain on the system. So really good public defender systems ended up finding themselves compromising and cutting corners and doing things that they never thought they would do before. Perhaps later someone will talk a little bit more in depth about finding yourself not able to provide what everybody agrees is the best kind of defense representation, called vertical representation, where the lawyer that meets with that client initially and gets their story represents them until that case is over, but the systems have found that they have to provide horizontal representation. That means that a single client's case might be passed off to 2 or 3, sometimes 4 lawyers until it's resolved, because it's more efficient to deploy limited resources in a way that provides representation in that fashion. So we know that there are these problems, and then the problems end up, the Supreme Court, on the one hand, does something good by making counsel available, but on the other hand, does something bad. And that's sort of the march from what I say DeCoster, which was a case that Judge Bazelon decided in the D.C. Circuit, to Strickland, which is the Supreme Court case, that talked about the burden that is on someone who makes an allegation of ineffective assistance of counsel. And in DeCoster, Judge Bazelon decided, well, wait a second, the burden of proving ineffective assistance of counsel shouldn't be on the defendant, because in essence, we start with the premise that the prosecution, the government, has a stake of proving guilt. But by now saying we're shifting the burden to the defendant to prove ineffective assistance of counsel, in essence, we're saying to the person, you have to prove your innocence. So that wouldn't be good. And secondly, when you have ineffective assistance of counsel, you don't have a good record. And appellate courts only could look at the record. So how could you tell from an absent record that witnesses that the defendant identified weren't called? It's not going to be in the record. How could you tell that the lawyer didn't do any investigation in the case? It's not going to be in the record. How can you tell that the lawyer in this capital case met with this defendant for a total of an hour and a half in the entire representation of that defendant? It's not going to be in the record. So Bazelon got it right. You know, the burden should be on the government. But the Supreme Court got it wrong. And the Supreme Court said, no, the burden, even if you prove substandard, first of all, the burden to prove substandard representation is on you, the defendant. But then secondly, you have to demonstrate to us that it was because of your substandard counsel at the trial level that you got convicted. In other words, when we look at this record that is blank in many respects, we have to conclude that there wasn't sufficient evidence and that there was some problem that your lawyer did that caused you to get convicted. So that's absolute, I would submit, insanity in the way the law developed, but that's the law we're stuck with. So inadequate representation of counsel is something that's tolerated by the system that we live in, because there are many cases where the court just goes to the prejudice. Have you proven that your lawyer's poor performance caused you to get convicted? They don't even examine the degree of that lawyer poor performance, and because they don't examine it, that means the defendant doesn't have a right to get out, but it also means the bar ethics authorities don't really look at the lawyers who are out there providing substandard representation. Well, the next point in something that I've had up there on the slide is this issue of case standards. And so the National Advisory Commission on Criminal Justice Standards and Goals set up case standards, and you can take a look and see what those are. I tried to bold the "or" at each point because it doesn't mean 150 felonies plus 400 misdemeanors plus 200 juvenile plus 200 mental health and 25 appeals, though I would suspect that there are many public defenders that have some combination of those. Shortly after, actually I think 10 years after these standards came out, an ABA Special Committee on Criminal Justice, then taking a look at what indigent defense services providers were doing on the case standards, first of all discovered that virtually no statewide system adheres to these standards. And then secondly, they said, wait a second, these are really the maximum conceivable case law standards. And, if you have a lot of serious cases, you've got to adjust them downward. And you need to have ideal support conditions. And you need to have investigators. You need to have support staff that are going to help you. So Phil has already talked about the basic ethical responsibilities that any lawyer representing clients has. But the problem that happens with someone who's a public defender is that the public defender doesn't have the same kind of control over caseload that a private lawyer or private law firm has. But the ethical obligations are exactly the same. And there are ethics opinions in bar disciplinary matters against lawyers that say case overload is not an excuse, and you can't go ahead and waive speedy trial rights. That's not an option. The only way you can waive speedy trial right and have that be an option is if your client gives fully free, informed consent. Basically you go to your client and say, well, I know you have a right to trial, and I know you've been saying that you're not guilty, and I know that we can have this trial next week and you can get out of jail, but I have so many cases, I'd like you to stay in jail for another 2 years while I work through my caseload to reach your case. Yeah, how many defendants would freely give up that right to have the trial? They don't. And so we have state court cases, we have ethics opinions that have been supporting that position. And in 2006, the ABA issued a formal opinion, and I guess this is sort of like the law of nowhere, because the ABA opinions aren't binding on anyone, but they do help move this big ship of the criminal justice system in certain directions. And basically, they affirm the right that when someone has a workload that is too great, that they should not take on more cases, and that your primary ethical duty is to your existing clients. And the other thing it does is that particular opinion talks about the interrelationship between the subordinate lawyer, the line public defender, and the supervising attorneys and the managers. And in doing that, they talk about what you need. You need some realistic weighted caseload standards. You need management that's taking a look at it. When you're the line lawyer, you go to your managing attorney, your supervising attorney, you tell them you can't handle any more cases. They're supposed to find a remedy, help you out. That might include them shifting some of your cases to somebody else. It might include providing, telling you don't have to fill out the 101 forms the state requires you to fill out every time you do anything on a case. They might say, okay, we're going to put that on hold for a while. But if they can't find a solution, you're supposed to go up the chain, even up to the board, Public Defender Commission in the state of Missouri. You're supposed to do it because the supervising and managing attorneys must support the line public defender who in good faith cannot take on any more cases and still provide ethical, competent representation to existing clients. And, that means that the supervising attorneys have to monitor and regulate the caseloads. They need to develop a uniform case definition that's meaningful, and and I know that in Missouri there's been a lot of work done on it, and I think because this problem has been with us for decades now, that there probably isn't any statewide system that hasn't done a lot of good work in that area. But in Missouri, and I'll conclude with a few remarks about a recent case, Public Defender Commission finally in having exhausted everything that it could do, having done things that 10 years ago they wouldn't have thought of doing in terms of the kind of demands expected of every public defender in the state, they decided there were going to certain cases they weren't going to take. And so one kind of case they wouldn't take would be one where a person goes and pays thousands of dollars to a private lawyer who doesn't do anything. And then the first time the lawyer has to do something, goes to the judge and says, Judge, I got $9,000, but it's going to take $30,000, and the client doesn't have the money, and so I want off the case. And the judge goes, okay, off the case you go. Doesn't look at how much work the person did, which in this instance, virtually none. Okay, but then says, okay, public defender, go ahead and take this case. Now you have somebody who's out $9,000, and they're not very happy that that money's not coming back to them. Now they have a public defender who has a ton of cases, and they want that public defender there, all the time. So public defender says, no, we're not going to take a case like that. That's a category we won't take. We're not going to take some of these probation revocation cases. We're not going to do that. And they're also saying that when they say we have the case overload, and the judge says to a public defender, well, okay, I understand your case overload, but I'm assigning you this case in your private capacity. All right? I'm not assigning cases to any other lawyer because, they're private lawyers, but you're a public defender, so I'm going to give it to you in your private capacity. Well, it turns out that when the Missouri Supreme Court looked at it, they said to the Public Defender Commission, you can't decide on your own the categories of cases that you're going to exclude. And so they denied those two writs. But they upheld the writ where the judge, and this is the reference I made to judges who don't understand public defenders that well, they upheld the writ and said, no, a public defender is probably the only lawyer in the state or other government lawyers who doesn't have a private capacity. So, no, you can't go ahead and get around the system in that way. And so it came up with what I call the Missouri plan, Missouri approach. I thought Missouri plan was too loaded. I don't want to call it the Missouri compromise in any way. But it is a compromise because what it wants is after you've certified for 3 months, you're at your caseload limit, that you're supposed to go ahead and try to go through a process that might have prosecutors agreeing to limit the kinds of cases in which they'll seek incarceration, or maybe judges will try to identify with the bar certain cases that the bar will step up and deal with. And maybe the judges will determine that, okay, we can't find counsel and these are minor matters, and so we'll just let the people go. You know, they've been in jail for 3 weeks and it's, you know, they probably get probation anyway. I'll just let them go, no conviction. So those are the kinds of alternatives, and I think Kat Kelly's probably later today going to talk about where the state and Public Defender Commission is now. But in closing, because I have no more time, the key thing, though, of this decision is it does recognize that if no agreement is reached, the public defender the Public Defender Commission can make the office unavailable for any more appointments until the caseloads fall below the Commission's standards. And so that's why it's a very important case. And it recognizes, like 2/3 of the other 21 states that have some kind of statewide public defender system, the public defender systems have to have the ability to refuse cases, because if they don't, Gideon means nothing, the Sixth Amendment means nothing, you know, and I would submit it's time for revolution. Thanks.
Thank you very much, Peter, Phyllis, Rodney. Thank you all for being here. Thank you for inviting me. When I thought about what I could contribute to this conversation, I've been lawyering for quite a long time. I've done a number of different things over that period of time. For the last 17 years, I've been a law teacher. And I think that I've learned something from trying to teach and trying to help my students become the lawyers that they can be and the lawyers that I think they can be, that I can bring to this conversation about public defense work and indigent criminal defense work. The profession has changed a great deal in the last 40 years. There are more lawyers out there, there are more law schools out there, there's more work out there. The world is more complicated, there are more regulations, there are more agencies, there are more kinds of complex legal ramifications to what we do in our life, and there are more cases. We are arresting more people, we are prosecuting more people, we've got more collateral consequences for cases. There's just a lot of legal work and a lot of legal problems to get our minds around. Working conditions for lawyers have changed, not just in the public defender offices where there are more cases and more lawyers and more to do. There's more record keeping, there are more requirements, there's more billing, there's more hours. There's more speed, there's more information. We're supposed to know more all of a sudden. We've got thousands of things coming into our computers. We're supposed to know all of the cases. We're supposed to know what's on the blogs. And we're working in bigger firms. We have to think about conflicts. We have to think about who was representing somebody 2 years ago. Was that witness that we're defending now? Was our client somebody that we're conflicted off of? There's just a lot of information that we've got to get our minds around. The ethics rules are different today. First of all, when I went to law school, we didn't even know that there were ethics rules, right? I mean, I'm teaching professional responsibility this year in my law school. This is a course that wasn't offered when I was in law school. It was a complete secret. Nobody knew what the ethics rules were. Nobody reported anybody to disciplinary committees, and if they did, we didn't know who handled it. We didn't know if there were hearings. You didn't know if you had a right to counsel there. Now there are professional staff at disciplinary committees. The hearings are in a lot of places public. It's something we're aware of. It's something that we pay attention to. It's something we learn about. What really hasn't changed as much as I would like to see is law school teaching. We're still pretty much teaching just the way I'm teaching right now. I'm standing in the front of a classroom, I'm talking to a bunch of people. There'll be some people here who will be paying attention, who will prepare, and who will be responding to me. And then there'll be a lot of other people who are multitasking. But the fact is that we actually know a lot more about how to teach, and we know a lot more about how people learn. And for that information, we are indebted to an ABA report that I guess came out about, I don't know, 15 years ago. Does everyone know about the McCrate Commission report, which was an ADA task force? I think the formal title of it was, let's see, the report of the task force on law schools and the profession narrowing the gap. And the commission's charge was to think about how to help law students become practicing lawyers, narrowing the gap, bringing the law students into practice, and to think about what skills law students needed that they would be immediately using and practicing. And this report came out of complaints from the practicing bar that young lawyers were graduating without the skills to help them actually practice. And so there were complaints from that side, and there were complaints from the law students saying, well, wait a minute, I've been sitting in these classes where people have been discussing appellate division cases with me for 3 years, but the first thing that I've been asked to do at the law firm is to draft a contract or go into court and make a bail application, and I actually don't know how to do this. So the McCrate Commission's job was to think about narrowing that gap. But before they could get into that, they had to think about, well, what are the skills that lawyers need to practice? And so they made a list of skills and a list of values which they felt that every competent lawyer must have. And if I was clever and had a PowerPoint, which I don't have, I would put these things up there. But instead I have to read it to you. The skills include things that we all know about: problem solving, legal analysis, legal research, fact investigation. How do we go about finding the facts? We want to defend somebody. They tell us they've got some witnesses out there, there are phone calls, they've got some kind of an easy pass. All of these different things will help them establish the fact that they weren't at the scene of the crime. How do we get it? How do we access it? How do we use it in trial? Communication skills. How do we talk to the clients? How do we do an interview? How do we negotiate with the prosecutor? How do we mediate a case? Organization and management of legal work. What do our file systems look like? How do we keep the files? How do we manage our correspondence? How do we have a tickler system set up so that we don't miss deadlines? All of those are lawyering skills which we know lawyers need. We know how to teach those things, and we could, in fact, teach them. Now, I've got a clinic, so I'm in a very lucky position in the law school. I have real cases, and my students get to learn how to lawyer by working on those cases. They take the responsibility for the cases. They handle them underneath my supervision. And in the beginning of the semester, we give those students a set of criteria that we are going to use to evaluate their progress as law students while they work on the cases. And we've used the McCrate Commission's report that identifies skills and values of lawyering as those criteria. So as the students progress and learn how to be lawyers, we can say, gosh, you know, I think you're doing really well on the legal analysis. You've spotted all the issues. There was a Fourth Amendment issue in this case. There was a Fifth Amendment issue in this case. There was a Sixth Amendment issue in this case. But your writing, your ability to articulate those issues, that's where you need some work. Or, hey, you understood the legal issues, but in terms of explaining them to your client, you really had some problems there, okay? You jumped into things too fast. I could see you turn this person off. You weren't able to establish those lines of communication. You could do that better. Why don't we try it another way? How do you think you could do it better? Can you reflect on that? So I can use those sets of criteria. I tell the students about that in the beginning of the year, and then we refer to them as we go on. People get used to thinking about their lawyering skills. They identify what they are, and they can improve in those skills. And even if, when they leave law school, they never ever go back to doing a criminal case again, since those are the skills that we use for all of the legal work we do, they'll be able to take those skills and recognize that they have those skills and apply them to all of the different tasks that they will be doing. Now, what does this have to do with public defender work, and why did I start off a conversation about improving public defense services with my experience as a law school teacher? Well, my thought was that if we can do this in the law schools, and we can do this in the public defender offices. and we can, and we deserve to, and we should be doing this. We should be doing this because we owe it not just to the clients, who I think will get better representation, not just to the clients who are innocent and might be wrongly convicted because people don't have time to work on their cases, but to all the clients who deserve to understand what's happening on their cases, to get the best possible outcomes on their cases. But we also owe this to our young public defenders. And not all of our young public defenders, but all of our public defenders. We owe them, they're doing a job that we all depend on. They are making our criminal justice system work for all of us. We need this. We need the criminal justice system. We expect it to work. We expect the cases to be processed. We expect the lawyers to do that for us. We depend on them to do it. And they deserve our attention in becoming the best lawyers they can be, which means they deserve to have some time for training. And the training should be tailored to what they do. We know how to do a good job at this. We can spend time brainstorming cases. We can spend time courting cases. We can spend time reflecting on what we do. We can take time out of the week to say, what went wrong this week? What was good? What did I like about what I did? How could I do what I like more often and more frequently? What did I not like? What was the problem? How can I do that better? What was this courtroom like? Or we've got a particular judge that we can never get discovery from. How could we approach that problem? Should the supervisor be going in? Should we all be going in? Should we be making joint motions? Defenders need all kinds of things. They need funding. They need independence. They need voice at the table with all of the other criminal justice stakeholders. They need caseload limits. We need all of those things, but we are not always in a position to make that happen. We're not in a position to get more funding all the time or to limit the number of caseloads. We can't always control it, and I know we can stand up and say, I'm just not going to take it anymore. We can do that. But one thing we also can do is we can try to control the conditions of our own practice. We can set some standards for ourselves and for our office. We can set performance standards, and part of the performance standards can be that we're going to have training. Every office shall have training. We'll have training for new attorneys. We'll have continuing legal education for attorneys who have been there. We are going to have supervision. We are going to have evaluation. And all of those different steps and stages are going to be guided by the performance standards that we in our office will establish. And this isn't, pie in the sky kind of thing. The Massachusetts Committee for Public Counsel Services, which is a statewide commission, which has a public defender office in the major cities in Massachusetts, but across the state is all assigned counsel. They have a set of guidelines, which basically are performance standards. When you join that public counsel service, you get this pamphlet. So it tells you, okay, here's how you submit your bills, here's how you'll get paid, here's what you have to do to get your voucher signed, and here are the things that we do in every case. Here are the cases here's how we investigate. Here's how we make motion practice. Here's how we make bail applications. And everybody gets trained on those standards. They have to go to training. They have to go to continuing legal education. And they have to be supervised. And the supervisors are there to say, how's it going? Can we do better? Where are the problems? Let's take some time out. Let's think about things. The goal is to allow people, to help people be the attorneys that they can be, okay? Because we owe that to the people who are out there in the field doing this work. We want people to enjoy that profession, to grow in that profession, to do a good job for their clients because they can do a good job and they want to do a good job. So, draft standards, give everybody a set of expectations, give different kinds of training, give different kinds of supervision, different kinds of evaluation. There's also other kinds of standards we could talk about. I'm just thinking here about performance standards that would be applicable to a public defender office. But there's also other kinds of standards we could talk about. All of the 18B private counsel people, we could talk about how can we improve the quality of services provided by 18B by having qualification standards, by making people meet certain qualifications before they're allowed to be assigned to cases. I don't think that's so much of an issue here in Missouri, though, because I don't think you rely too much on assigned counsel, do you?
Not at this point.
Yeah, not at this point. If you start doing that, you need to think about administering the assigned counsel plans so that they don't become a plan that anybody can get on, and that before someone actually joins the plan, they have to have a certain level of experience and a certain amount of training. And then the other thing that happens in some places is that there are standards which you can use to evaluate the performance of an office in itself. So this would be standards that you would use to take a look at how an office is doing. So for example, the ABA evaluates how law schools do. The ABA comes in with a site committee and they say, now we want to see about this law school. How good is this law school doing? So the first thing they do is they have a set of standards. Okay, what are we going to look at? What criteria will we measure to decide how good this law school is? And they don't really know exactly what to measure, so they say, well, how many books are in the library? How big are the classrooms? And how many people are passing the bar? And what's the ratio between the number of teachers and the number of students? They try to come up with things which they think will show them how well that law school is performing. And they ask the law school to do a self-study and tell them, where do you think you're doing well? Where do you think you're doing badly? Where do you think you could be doing better? And then they send a team in after the team has read that self-study, and they compare what they see in the school to the set of standards that the ABA has come up with that they use to measure the office. And through that process of having the law school talk about what they're doing, having the law school talk about what they're doing, and the site visit, all looking at a set of standards, they come to a conclusion about how well the law school is doing. You follow? We can do the same thing for defender organizations. We can write a set of standards that says, we want all organizations, okay, all public defender offices that provide criminal defense services shall have caseloads standards. Okay, that's criteria 1. 2, they shall have performance standards so their lawyers know what it is they're expected to do. 2, we shall have training. All the lawyers must have the opportunity to go to training. That training must be at a time that they can go. Okay, we're not going to have training while they're in court and can't get there. We're going to have training with materials that they can take away. Everyone's going to have supervision. They're going to have an opportunity to talk to somebody about their cases. They're going to be evaluated so that they know when someone's promoted, why did they get promoted? Most offices I've ever been in, you never know why one guy's promoted to supervisor and why one guy isn't promoted to supervisor. What are the standards? So we can do that and then use those standards to have your state commission or whoever it is that you trust to do this evaluation come in and take a look and give you some guidance. So standards could be useful in a variety of different ways. And I think we know what it takes to be a good lawyer. We know how to teach people to be good lawyers. And we can do it. So thank you very much.
Well, good morning, ladies and gentlemen. I appreciated Rod's kind comments about me when he introduced the speakers for this program, but he did an outstanding job of telling all of you just how old I really am. Nevertheless, Rod, I thank you for your comments. I'm delighted to be here and delighted to have the opportunity to comment on my colleagues' remarks over the past few minutes, and to also share with you some perspectives about indigent defense in the United States, as well as here in Missouri. Adele, in her remarks just a few moments ago, talked about the need for standards, especially performance standards. And I certainly don't dispute the importance of those standards. And indeed, there are all kinds of standards we have in the United States dealing with indigent defense. The truth of the matter is they don't mean anything. They don't mean anything at all unless a lawyer has the capability of representing his clients adequately. Performance standards were developed by the National Legal Aid and Defender Association in 2006, I think it was. They published the 4th edition of their performance guidelines, and they're excellent. They don't mean a thing when you can't represent your clients adequately. And never have I seen a clearer illustration of it than an order that was entered by the Nevada Supreme Court on January the 4th, 2008. This is after a report from a commission in the state of Nevada. It is hereby ordered that the public defenders in Clark County and Washoe County shall advise the county commissioners of their respective counties when they are unavailable to accept further appointments based on ethical considerations relating to their ability to comply with the performance standards contained in Exhibit A to this order. They delayed the implementation of the performance standards, but some months ago now they said they are fully applicable. They're being totally ignored, and no program in the state of Nevada, except one, which was a statewide program of some small dimension, has really ever protested a caseload in Nevada. And meanwhile, the caseloads in Clark County, where Las Vegas is, and Washoe County are incredibly large. But they've taken no action at all. And that, truthfully, is the story throughout much of the United States today. Phyllis talked about federal involvement and the conference that was held last week in Washington, D.C., where many of us were present and had an opportunity to speak. And it is true that the Attorney General of the United States is, I am convinced, personally committed to this issue. But the real question that some of us want to see answered is whether or not federal funding will ever be promoted by this administration. Because the truth of the matter is, unless the states are aided at the federal level, I remain pessimistic that the 50 different states with 50 different systems will be sufficiently forthcoming, adequately to support public defense in the United States, at least not anytime real soon. If you think about how we got to where we are today, remember that what the Supreme Court of the United States did in this country was not to pass legislation. They issued an opinion. And indeed, several of them, after Gideon, which came in 1963, they issued several more opinions about the right to counsel, but it was collectively an enormous unfunded mandate. Actually, not enormous when you consider the cost of prosecution, police, health care, corrections in this country. It was not an enormous unfunded mandate, but it nevertheless has lacked the political will in state legislatures for the funding to be forthcoming. Unlike in England, for example, where it was all done through legislation. And England, which passed legislation for England and Wales, has funded it, relatively speaking, far better than the United States, and so has Scotland. But it started with a piece of national legislation of a kind that we simply have not had here. And indeed, we've had very, very, very little federal support to implement this federal constitutional right to counsel. Now, I want to mention a couple of other things that my colleagues touched upon and then talk some about caseload specifically in Missouri. There was mention made of the National Advisory Commission standards, and you had up on the screen these numbers that date all the way back to 1973, a body known as the National Advisory Commission on Criminal Justice Standards and Goals published a booklet on the courts. And in one of the standards there was a recommendation about caseload numbers. 150 felonies as a maximum for a lawyer, 400 misdemeanors, 200 juvenile cases, and then there were some others. And they often are referred to, remarkably, as national caseload standards. Go back and read the commentary to the court's report. It's remarkable that it has been somehow ignored for decades. What the commentary says is, there was a committee meeting of some lawyers from the National Legal Aid and Defender Association, and they suggested these may be appropriate numbers. And then it said, we accept the committee report of NLADA. They did no empirical work. They did nothing at all except a committee report from NLADA. And I know one of the people who was involved in that at the table, because I am so old, and I will tell you that what they did then was simply pluck them out of the air. And somehow they have gotten to the point of being national caseload numbers. When you read the commentary in the court's report, they tell you of all the dangers of relying upon these numbers. And they suggest unequivocally that there are all sorts of problems with it, and they were never intended for an individual lawyer, at best for an office, and it was suggested they ought to be regarded as maximum numbers. But when you look at the very best public defense programs in the country, and including one private defender program that I visited several weeks ago in California, all of the lawyers tell you those numbers are absurd. If you are going to competently represent your clients, you cannot typically have as many cases as was suggested back in 1973 in this report. And so I would simply urge caution in talking about those numbers. Oh, incidentally, for several years, there's a research arm of the National District Attorneys Association. They came out with a report several years ago, and they said they wanted to develop, if they could do it, because they knew they had existed somehow on the defense side, they wanted to see if you could develop numbers of cases for prosecutors. And you know what? After several years of study, they issued a report and said, you can't do that. There are so many variables. Support staff is different. Crimes are different. You just can't come up with numbers for an entire country. It's got to be a matter of some individual study, but it's really more than that, as I'll mention in just a minute. I want to say a word about the ABA ethics opinion. And I suppose I want to say something about it because I was so deeply involved in encouraging it being written. The idea behind that ethics opinion actually started during a program that I was moderating at an ABA annual meeting in 2004. And a friend of mine, who was then the defender director of NLADA, the National Legal Aid and Defender Association, said, why don't we ask the ABA Standing Committee on Ethics and Professional Responsibility to issue an ethics opinion in this area? And I said, well, you know, that might be a good idea. Well, after that, I believe in January, he wrote on behalf of NLADA a letter to the Ethics Committee, and the council, the Ethics Council of the ABA wrote back and said, well, we issued several opinions dealing with legal aid offices, and we said that you simply shouldn't take these cases. If you have too many, we don't need another opinion. Well, then I really got upset. And on behalf of the ABA Standing Committee on Legal Aid and Indigent Offenders, with which I've been deeply involved for many years, I wrote a letter on behalf of that committee to the Ethics Committee, and I said, you don't understand the difference. I said it more nicely than that. You don't understand the difference between legal aid and public defense. The lawyers across this country can't simply refuse cases most of the time because the judges will insist they take them, the judges will appoint them. You really have to go hat in hand to the court. Well, that led to a reconsideration. I had a phone call with the Ethics Council, and then we had a hearing, a very unusual personal meeting with the Ethics Committee to try to persuade them to write an opinion in this area. And I never doubted what the opinion would say. never doubted for a moment, I've taught ethics for years, there was no question what lawyers have to do when you have too many cases. You have to try to stop additional appointments, you have to seek to withdraw, because Rule 1.16a says you cannot engage in lawyer activities that will constitute a violation of the rules of professional conduct, and the rules of professional conduct require that you be competent under Rule 1.1 and that you be diligent under Rule 1.3. By the way, those rules of the ABA are exactly the same here in Missouri, because I looked at the rules in Missouri before I came down here the other day. They are really not rules from nowhere, they are rules from Missouri and virtually every other state. Well, during this hearing, the Ethics Council of the ABA, who really wasn't sure he wanted to see the committee do this, said to me at one point, "Professor, what you really want is an opinion by this committee that lawyers in the United States will use in order to try to get states to provide more money." I said, "Well, you know, George, I'd be happy if that happened, but that's not my real overriding concern. My overriding concern is that as a professor, we teach students how to do it. We teach them how to represent clients, and then they get put off into public defense programs, so often in different parts of the United States, and they are introduced to a kind of lawyer in the state courts and in the county courts, which is exactly the opposite of what they've been taught to do, especially in clinical programs. And they become corrupted by that system, and the culture of public defense in the United States permeates the thinking of many defenders. Some of them obviously rebel and want to see things done very differently, but some of them don't quite understand they are not doing what they need to do because they don't fully understand it in terms of what their obligations are. The materials that you were given, just to jump ahead for a moment, include something that's very recent. When do you want me to stop here?
You got a little bit more time.
3?
No, 3 would be a bit much, but 10. We can go to 10.
I'll try not to do that. The materials that you've been given for this conference include something that's very recent that most of you have probably not seen. It is on the website of the American Bar Association Standing Committee on Legal Aid and Indigent Defendants, www.indigentdefense.org, and it's 8 guidelines dealing with excessive workloads in public defense. And what we sought to do with those guidelines, it was approved by the House of Delegates in August of 2009. It has not yet had a lot of publicity, but we hope to change that. What we sought to do with those guidelines was to build upon the rules of professional conduct as well as the ABA's ethics opinion. Because after the ethics opinion was issued, and the more I thought about that opinion, I realized that there were some things that were omitted that ought to be covered. Included among those was an effort to spell out in Guideline 1 the symptoms that typically occur when the caseloads are totally unreasonable. And therefore, in effect, amplifying Rule 1.1, the rule on competence, we talk about various things in Guideline 1 that lawyers need to be doing in representing their clients. And we also talk about a kind of training that lawyers need to receive, not just the kind of training, Adele, that you spoke about, but training in what their ethical duties are when they have too many cases, among other things. They need to talk to their supervisor. They need to try to get some understanding about what that next step is going to be when they cannot provide competent and diligent representation, and they obviously need to be supported by that office, as I think those guidelines make absolutely clear. The reality is that very few individual defenders are going to step forward. So it has to come from the leadership of the program. And the leadership of the program, it seems to me, has got to be, in this day and age, extremely vigorous. So let me talk in just a couple of minutes remaining about Missouri. I know, because I have looked at the annual report and I have followed the Missouri scene here for some time, that the leadership of the Missouri program and the Missouri Bar, they have vigorously sought to deal with this problem. And they've been concerned about the problem, rightly so. And ultimately, they did get this opinion from the Missouri Supreme Court in December of 2009. By the way, when I say that they've been talking about the problem and trying to deal with the problem, they obviously deal with it in their annual report. And in what it seems to me to be, if you think about it for a moment, a remarkable confession, maybe confession is good for the soul, they write in their 2009 report, the struggle has turned into a full-blown caseload crisis with lawyers forced to triage their services. And that, mind you, was based upon the 2005 report that was done of the Missouri program, in which the report said the probability that public defenders are failing to provide effective assistance of counsel and violating their ethical obligations to their clients increases every day. And indeed, you can't read the 2009 decision of the Missouri Supreme Court without concluding that the Missouri Supreme Court believes that the lawyers are violating their ethical duties. I think it's patent from that opinion. Similarly, they cite with appropriate reference to the ABA ethics opinion the fact that supervisors have a responsibility. They quote the ethics opinion. Supervisors have a responsibility under Rule 5.1 of the Rules of Professional Conduct to take appropriate steps. Those aren't the exact words, but that's the sense of it. To take appropriate steps to avoid the problems for the line attorneys. And so, in this whole long history of Missouri, on this caseload problem, which isn't just of the last year, this has been going on for years here. Has there ever been a lawyer walking into court with a motion to stop additional assignments, to withdraw from cases, to do what the rules of professional conduct require?
No.
And the answer is no. Thank you. I thought I knew that answer, but I appreciate the help. Now, I know there are lots of forces at work. But you know what? When you talk about revolution, Peter, we are almost 48 years next month to the Gideon decision. And state legislatures are facing all kinds of problems. But I have become convinced as I've gotten older and more militant than ever, that unless you make a very concerted effort to move the system, it won't happen. And I'm not at all convinced that that Missouri decision is an answer. I mean, first of all, they say, well, you've got to have 3 months of too many cases, and these are caseloads that are like the NAC numbers, as I understand it, except for some discount for sex offenses, which take more time. But you've got to have 3 months. And then if you have 3 months, have a little conversation, do some collaborative work. There's nothing in there about withdrawing from cases. Apparently those clients who are part of a caseload where there are way too many, they just are victims of what the buildup has been, including the 3-month period. And then you're going to be unavailable for a while, but you've got to convince the judge, you've got to give them statistical information. What I don't understand, and I've never known a defender program to do this, what I don't understand is why a somewhat different course isn't taken. And I think it has to come from the top, because it won't happen with individual lawyers. I don't understand why lawyers do not make a record in every single case where they do not believe that they can provide competent and diligent representation as required by the rules of conduct, and why they don't tell the court that I do not believe I can provide reasonably competent assistance of counsel as required by Strickland versus Washington. you don't know whether there's going to be prejudice, because that's an after-the-fact determination. I mean, one of the reasons why the ethics opinion was seen as a wonderful solution to this problem was that it got away from Strickland, which is a terrible test. Even though I heard Sandra Day O'Connor a year and a half ago proclaim it as an opinion of which he was most proud. No opinion that I know of by the Supreme Court has been subjected to such remarkable condemnation as Strickland versus Washington, and appropriately so. But the ethics opinion avoids all that. So we thought, how many times since that opinion was rendered in May of 2006 have public defense programs come forward and filed formal motions to withdraw? Some of them may have succeeded behind the scenes informally with courts, but I know of only 4 cases, and I was an expert witness in all 4 cases. One in New Orleans, one in Kingman, Arizona, one in Knoxville, Tennessee, and one in Dade County. And they were full-blown affairs. They took a lot of time. 2 of them are still in the appellate courts, Knoxville and the Tennessee case and the Dade County case. Incidentally, in the Dade County case, which Wayne Logan is going to talk about, I gather, lawyers had post-arraignment, on average in the first case, over 700 cases that were felonies over the course of a year. And in the other case, the lawyer had over 900, although I'm told by the head of the office, the lawyer who had received over 900 felony appointments wasn't really convinced he was doing anything unsatisfactory. He needs to read Guideline 1 of the ABA's excessive workload. Well, I think it's a tough road to hoe, and it's, you might say, I'm sure some will say, well, it's easy for him to say, after all, he's off in the ivory tower, and he's not even from Missouri, so he's got a license to say whatever he wants. And I have enormous empathy for those who manage public defender programs and for lawyers who are on the front line, but I have become convinced that a very strenuous effort needs to be made to deal with this issue. And lawyers ought to protect themselves and protect their clients. And let the media learn about it. Spread the word, and spread it in every case on the record. I think it would, in the end, be effective, at least no less effective than what I've seen happen so far, nearly 50 years after Gideon versus Wainwright.
I have just a couple of observations, and then we're going to open it up to some questions. First of all, I think all the speakers and Norm made it abundantly clear that in this country, where you live makes a huge difference in the quality of representation that you're going to receive. Not only where you live, but obviously the amount of money that you have. In the Duke Lacrosse rape case that I wrote about, the lawyers in that case, in defending those 3 accused rapists, spent over $1 million in the defense of that case. If you were arrested in any county in Oklahoma outside of Tulsa County or Oklahoma City, you would be represented by a contract lawyer. That's a private lawyer paid on a contract basis to provide representation to indigent defendants. And the average pay would be $191 a case. Not per hour, but a case. So if you are facing life without parole in Oklahoma, that's what your lawyer is going to get paid. And I ask you, what kind of representation do you think you're going to get for $191? You're not very good representation. That's the answer. Second, one of the big problems that was described by our speakers today, and one of the concerns that I have as the Missouri folks take a look at reforming their system, is the extent to which we play with indigency standards. When public defender programs get into trouble, the way they deal with that too often is they raise the eligibility standards. And what that then means is more poor people who can't possibly afford quality representation or any kind of representation are now left to depend on their parents and their friends to raise the money. And we're talking about people oftentimes who are working at McDonald's, and suddenly they work at McDonald's, but they now make too much money to qualify for a public defender, and they receive the worst representation in the whole entire United States. So we can't afford to deal with our crisis in indigent defense by stripping more people from representation and letting them fend for itself. That's no answer to the problem.
I just want to give a hand to that. I agree
Okay.
with that.
The third thing that was as I was listening to the speakers today, I'm mindful of, is we also, in answer to qualifications, Wisconsin Public Defender Program is one of the best in the country. And I'm proud to say, in response to Norm, that we did train our lawyers when they went in. If they were unprepared, they said, "Judge, you can find me in contempt, but I am not going forward." And we, the supervisors in the office, went over and we backed them up. We would not allow any of our lawyers to go forward if they were not prepared. And they threatened us with contempt, and ultimately the judges blinked because we had enough power in that system to be able to make sure that it worked. That isn't true in many jurisdictions across the United States. It's probably not true here in Missouri. But the answer is not to simply then say, well, we'll appoint it out to private lawyers, and then those private lawyers, untrained, often unsupervised, often unqualified, and then once again, we've offloaded the problem. We haven't solved the problem. And so if we are going to deal with it by dumping more cases in the private sector, we have to make sure that we have training, qualification. We had that problem even in a good system. I walk into court because we appointed 25% of our cases were handled by the private bar. And I was responsible for monitoring their work. And I'd walk into court and I'd see this walking Sixth Amendment violation, and I would go back and I'd say, I want to take this person off the list. Well, that became a huge political issue. Okay, so it's not an easy solution just to say we're going to turn it over to the private bar. That's a huge problem. And the last little bit is the conflict between line lawyers and supervisors. That's a problem all over the United States. You need to have supervisors who do in fact have the back of the people in the trenches, but there's a real tension. When we were doing eligibility determinations, the line lawyers always wanted to take more cases because they saw the individual client. They knew that individual client, if we found them ineligible, would then go out and fend for themselves. So the lawyers in the trenches took more cases. The supervisors said, wait, we're now at our caseloads. We now have to offload more cases to the private bar. That causes some real financial problems for us. And so we had an ongoing tension between the online lawyers, the in the trenches lawyers, and supervisors. That's another issue that I hope we'll get into more in our second and third panels. So any questions? We've got a couple more minutes before we're going to go hear Steve Bright. If you have a question, just raise your hand or a comment by one of the other speakers.
I have a question. For all the panelists, what do you think about advising your clients, this would be at the trial level, all of them to file speedy trial motions?
So are you ready to go to trial? Because you can't ethically say you are if you're not, right?
Well, that's what I'm, like, sort of pushing the system. They have to be tried within 180 days. And if all of the clients are demanding a trial within 180 days,
Well, they're doing that on their own here, aren't they? I mean, I just was reading about how all the defendants are writing their own pro se speedy trial motions here in Missouri. You didn't know about that?
I
No.
haven't seen any evidence.
Yeah.
The danger, of course, is that, we can't play chicken with our clients and their cases, right? And the idea of sort of, building up a critical mass to break the bank, so to speak, is something I think we all, from time to time, think maybe that's the way we ought to go. But, what we have to do is I think, as Norm said, we have to make a record, right? So I think, if you're not ready to go to trial and you're not prepared to try your client's case, then him saying, I want my trial in 180 days might get him a trial in 180 days, and there won't be a record, and, it won't get reviewed on appeal, and he's just screwed, right? So I think that perhaps the better course, and others may disagree with me, is for you to file the motion that says, I am never going to be ready to try his case, ever, because I don't have an investigator or a social worker. I can't interview the witnesses. I can't go out and test DNA. I can't blah, blah. So rather than filing a motion that's sort of untrue, client wants to go to trial in 100 days. No, he didn't. He wants a prepared lawyer. So file that motion.
What about encouraging clients to sue the state?
Well, I don't know that we can really leave it to the clients. You know what I mean? I don't know that we can leave it to the clients to sue the state. You might want to think about a legal action. You might want to think about plaintiffs and which are the best plaintiffs to use to sue the state to say that they're not getting adequate counsel. But it would really have to come from the lawyers, and it would have to be a concerted effort amongst everybody here, and you'd have to bring in some, private bar support to help you do that, and you'd have to prepare for it by using the reports that have been done and by getting some newspaper articles out there. I mean, that would be a big concerted effort, and it might be something that you would want to consider. Other states have had some success doing that. It certainly does educate your legislatures. You might, leverage some more money that way through the, the pendency of a case. But it couldn't really be something that you would be encouraging the clients to do. The clients might help you with it, but it would be a legal strategy that you'd have to feel pretty comfortable about and figure out what your cause of action is and prepare for it over a long time, I think.
And our second and third panels will be dealing more with litigation and ways to address at a larger level some of the problems we've identified.
Yeah, I have a question. Wisconsin, a big difference in their public defender organizations. They're unionized, am I right?
No, well, they are unionized now, but that was an after. That's really not, I don't think, a significant factor in the development of the system or in the strength of the system. Give you a quick statistic. Back in, I think it was 2004, I looked at the difference in funding for the Wisconsin program. $78 million was spent in indigent defense. Missouri at that same year spent $33 million. Oklahoma spent $17 million. Oklahoma and Missouri are two states that use the death penalty a lot, and actually most of the funds, or much of the dollars were being spent on the defense of capital cases. In Missouri and Oklahoma, disproportionate share. In Wisconsin, obviously, there isn't a death penalty. So I think that it's the biggest difference in Wisconsin is it was adequately funded right from the get-go. The union came in about 3 or 4 years after it was funded. So I don't think it's a significant issue in differentiating that particular state program from the Missouri program.
Rod, can I just add one comment to that? In terms of adequate funding in Wisconsin, Wisconsin has a fabulous public defense program, but their eligibility standards are incredibly high.
Absolutely.
And so,
absolutely.
They, in terms of adequate funding, obviously they're not adequately funded because there are tons of, Wisconsin probably has the highest eligibility standards in the country, and by that I mean you have to make no money. You have to own nothing to be entitled to counsel in Wisconsin, else you're out on your own, okay? And so, if you have $200 in the bank, or if you made bail, or if someone made bail on your behalf, even though you have no resources of your own, you're not getting counsel in Wisconsin. And just the second thing is that Missouri, on a per capita funding basis, is 49 out of 50 states in the country. So, you're only above Mississippi.
And just to follow up on that, one of the hidden factors is in Oklahoma, and I believe it's also the case in Missouri, if you make bail, most places you will be denied access to counsel. So oftentimes if you've got to choose between, hey, I need to get out, I'm not guilty of this crime, I need to get out so I can maintain my job, so I can continue to feed my family, and if I do choose and my family chooses to post bail and get me out, then I'm ineligible for a public defender. That's lunacy.
Yeah, well, in the other part of the lunacy of that is, okay, you're ineligible, then you don't get a private attorney, and so then the court appoints the public defender to represent you. But meanwhile, it takes all this extra time, and then on top of it, and this is contributing. It's probably a small amount of it, but it's really contributing to the problem. Are the number of private lawyers who take money from clients, don't do anything, and judges give the same lawyers a free pass in case after case after case. And it's just, it's lunacy.
Okay, this is obviously a good discussion. We want to continue, but Steve's going to be talking in 3 minutes. So in order to keep us on schedule, this discussion will continue on this afternoon after you hear Steve's compelling, powerful talk. I hope many of you will come back this afternoon so we can continue this discussion.